Hi, this is Layli Miller-Muro, the CEO of the Tahirih Justice Center. I just did a botched Facebook Live a couple of minutes ago that didn't work because of a signal problem. I'm hoping this will be better. This morning, the Supreme Court issued a decision in the travel ban case that is significant. It's a partial decision, but it specifically is a decision on the injunction. And what has been happening for the past few months is that multiple courts throughout the United States have been looking at the executive order. You may remember that in earlier this year, there were 3 executive orders that were issued. 2 of them dealt with the treatment of immigrants inside the country. One of them, which has been affectionately called the travel ban, dealt with those who are outside of the country trying to come in. Multiple courts issued an injunction against it, which was not a substantive finding on whether or not it's constitutional, but was a legal determination that there was sufficient evidence that it would succeed on the merits. It had a likelihood of success on the merits, and that it would cause irreparable harm if it continued to be implemented. And so there was an injunction issued that put the travel ban on hold. Now, of course, that was after a lot of chaos at airports and confusion and damage that was done even in the brief period of time that it was implemented. Up until then, multiple court jurisdictions have been dealing with the legal decisions in the case, and it all now has culminated to the Supreme Court. And we knew this day would come. We've been waiting for it. And finally, this morning, the Supreme Court issued its decision. Now, what they did not do was decide the issue of constitutionality of the travel ban. And so really what is at stake there is the question about whether or not the travel ban is a veiled or not so veiled Muslim ban, and to ban anyone from the United States on the basis of religion is unconstitutional. And so that's what people are talking about, and that's the legal issue that people are really eager to get to, but this decision today did not do that. What it did is it looked at whether or not the injunctions, so these decisions that were made by the other courts to basically say we are going to suspend the implementation of the travel ban until we can answer the questions around whether it's constitutional. This Supreme Court decision today looked at simply the issue of injunction and particularly the scope of the injunction. What they decided was that the injunction was too broad. And so the injunction basically said the whole travel ban with regard to everything that it says it's trying to do has to be put on hold. What the Supreme Court decided today was not all of it has to be put on hold. And so I'm going to describe to you which bits are on hold, which bits are not on hold. But suffice it to say that it was simply a decision on the injunction, not on the underlying constitutionality. They did put in a briefing schedule, an oral argument schedule for October. So we're going to have to wait a few months, a long time it feels like, to get to the underlying legal issues, which will be argued in October. But in the meantime, there are parts of this travel ban executive order which will now be implemented, and they've been on hold for a long time. So basically, what they decided was that the preliminary injunction was overly broad. And so what it said was that even people, when lawsuits are brought, they're always brought on behalf of individuals or institutions, but they're brought on behalf of real people, real companies, and real things. And what the court said is the people who brought these lawsuits would have suffered irreparable harm. They would have been damaged by the travel ban, and so we're going to continue the injunction with regard to them. It's these hypothetical people who are unconnected to a company, a state, an individual. It's too hypothetical to implement the injunction against those people or companies. And so they limited the scope of the injunction where it applied to everything around that executive order. Now it's only applying to very limited circumstances. So specifically, it held that the travel ban will now and immediately now, which is also problematic because you'll remember the last time there was an implementation of the travel ban without any warning to any of the poor agencies and officers and airports and other individuals that have to be implementing this. We're now, I think, going to face similar chaos because the Supreme Court issued this decision without warning to those agencies that they're now going to have to implement it. So the travel ban now applies immediately to, quote, foreign nationals from the 6 countries with no connection to anyone in this country. So these hypothetical people, as opposed to actual people with relatives, business interests, school visas, and other connections to the country. So it's people without any connection to the country that the travel ban is now being implemented against. And just as a reminder, the 6 countries affected are Syria, Sudan, Yemen, Libya, and Somalia. Syria, Iran, Yemen, Libya, Sudan, and Somalia. Those are the 6 countries that are affected by the travel ban. And it now affects them and affects all foreign nationals who have no connection to this country. It does go on to explain what connection to the country means. And the travel ban will continue to be blocked for people who have a credible claim, and that language, credible claim, is legally significant. A credible claim of a bona fide, which means a genuine or a good faith relationship to someone or an institution in the United States. So if that applies to you or loved ones, then the travel ban is not affecting you. It is still under the injunction and it's still on hold. When that relationship is with an individual, the court made clear that it must be a close family member. So it cannot be a distant relative or a distant cousin. This has to be a close family member who's trying to come into the country from one of these 6 banned countries. If the relationship is with an institution, the court made clear that it must be a close one rather than a created one, just to get around the travel ban. So some examples that they gave are a student who has been accepted to a university in the United States. That would be a close relationship with an institution. A worker who has accepted a job in the United States with a specific country, that would be a close relationship, and the travel ban wouldn't apply to them. A lecturer who accepted an offer to lecture. So again, it's not hypothetical or in the future, it's a current relationship. An example of a relationship that would not be considered a close relationship with an institution is an NGO who reaches out to foreign nationals, signs them up as clients, and then claims the exclusion of the ban based on the client relationship. So probably moments in time are going to be important. Relationships that are created after this decision today will be suspect. Relationships that were established before will fit under the exception, and there will be a burden of proving that it wasn't a manufactured relationship in order to get around the travel ban. Now, you'll remember that the travel ban applied to anybody seeking any kind of visa from these 6 countries. There was a separate part of the same executive order that dealt with the processing of refugees into the United States, and it suspended refugee processing. And so similarly, the executive order says that the decision of the Supreme Court today says that refugees who have a bona fide relationship with someone in the United States cannot be barred from entering. So it all has to do with this idea of relationship. If you have a relationship with an institution or a person in the United States, then the travel ban will not affect you. If you don't, the travel ban from these 6 countries will affect you, and you will not be able to enter the United States. Interestingly, on the refugee part of this, most all refugees already have relationships with people in the United States. I've talked before about just how hard it is to get resettled in the United States as a refugee. We have the most stringent security processes in the world. It takes an amazingly long time. People can be languishing in limbo for years and years and years while all the paperwork, the medical work, the security work is all managed and completed for them to get refugee status in the United States. And so really, most all refugees who are coming to the United States anyway already have these ties. They're coming because they have family members here who can help them out. So hopefully, really most refugees planning on coming to the United States will not be subject to this travel ban. Something very interesting about the decision is that it also does not allow the 50,000 number cap to take effect. And this I find very interesting because every year the President of the United States has very clear authority to set the numeric limits on how many refugees could come into the country. That executive order set a cap of 50,000, and the court here is saying that that 50,000 cap will not apply where a refugee is being resettled and has a bona fide close relationship with somebody already in the United States. So actually there's some ambiguity about that whole part of this decision around the refugees. Then finally, the court gives the government 90 days from today to complete the review that they were supposed to do during the refugee processing pause. So you may remember that the initial logic given for suspending the refugee program was to make this extreme vetting notion. Even though we already have the most extreme vetting of refugees from a security perspective and every other perspective in the world, there was this notion that we were going to make it even more extreme and that it would take 90 days to do that. The court is basically saying, all right, it doesn't apply to refugees who are coming into the country who have connections, and then for those who don't have connections, you've got 90 days to figure out how much more extreme vetting you want to do. So they've put a very firm deadline on that. And then the court leaves open and asks for briefing on the question of whether or not the whole stay issue is moot altogether, which means it's kind of no longer an issue because of the expiration date around the travel ban that was included in the executive order. So the travel ban, which came out, the second version, came out on March 16th. The first version came out in January. But the second version of the executive order travel ban came out on March 16th. And in it, it said it would expire after 90 days on this particular provision on June 14th. Well, June 14th has already passed. So the court left open to interpretation the idea that it could be moot completely because of that self-imposed deadline. So that's the nuts and bolts of the decision itself. There were some interesting things about it. It was a per curiam decision, which meant that we don't know who wrote it. There were no names attached to it, which is kind of interesting. There were 3 judges who decided to dissent on it, and then they said something weird in the dissent, like, we believe that the court, through its decision, has made an implicit decision that the travel ban is not problematic, which was a really weird thing for them to say. I mean, most judges will make comments based on law, but not conjecture, and the dissent in this instance has a lot more conjecture in it than law. Also, a fun fact is that our most recent Supreme Court Justice, Gorsuch, was a part of that dissenting opinion. There were 3 judges, Thomas, Alito, and Gorsuch. And so I think that's about it. There was no dissent from the judges that you would expect to dissent, who are likely in opposition of the travel ban. They're probably saving their arguments for then because the merits weren't decided in this decision. There's a lot of how this is going to work in practice that is unclear, and I'm sure we'll be hearing about that in the next few days. Also, something just interesting about it from a legal perspective is this language around a credible claim of a bona fide relationship and this definition of close relationship that gets you around the travel ban if you're from these 6 countries. Credible claim, legally speaking, is a lower bar, it's a lower standard and easier to meet than using language like demonstrating or showing. Because when you use language like you have to demonstrate or you have to show that you have a close connection with a person or an institution in the United States, it's a higher bar of proof, and they didn't require that. They said you simply have to have a credible claim. So that is going to make it easier for people to show that they have a relationship with a person or an institution and that they shouldn't be subject to the travel ban. The net of this, for those of us who work with immigrants and refugees, is not good news. The travel ban, all of the chaos around it, the fact that people really needed legal defense in order to protect loved ones who are fleeing, like those fleeing Syria, war-torn, horrible situations that any mother would do her best to flee on behalf of her child. It is these people who will be most affected by the travel ban. It will harm people. It will prohibit people from coming into the United States who are not terrorists, who are in fact victims of violence themselves. And that part of this is concerning. And then there are some logistics issues that are also very, very concerning. So I'm sure there'll be a lot more to discuss later, but that's the summary of what it means. Thanks.